couple of minutes of intro, so I'll do the first 2 slides, all the sort of disclaimers and things like that, and
now live.
Talk about questions. Right. It's early. Currently, it's just Anna. We shall give it a couple of minutes. Morning, everyone who's just joined. I think we were expecting about 30 people this morning, and we're on relatively low numbers. So what I will do is I'll wait a couple more minutes and start at 20 past, and then speak slightly faster if needed to get through all the material. In the meantime, I'll just drink my tea. Looks like we're a very elite group. Jonathan, shall I start just and get through all the introduction, because I know you've got a lot to say, and we'll just do the sort of the slightly duller bits, and then get cracking. As I say, we were expecting a few more people, but this is an elite group. Unfortunately, we're not in person. Otherwise, we would all pull up chairs and get together and turn this into a proper round table. But never mind. I will get cracking. Good morning, everyone. Zoom exhaustion's clearly starting to set in for online seminars, so thank you very much for turning out. I hope you find our talk useful. It's a bit of a follow-on from my talk at the end of last year about planning enforcement, which I think some of you attended, but the reality is that this is a standalone topic, so Jonathan and I are coming to it afresh. You'll be hearing from 2 of us this morning, Jonathan Welch, a 2019 called barrister, who's already established a busy, successful, interesting junior practice, and he's going to be talking to you about injunctions. And then you have me, Michael Fry, a 2011 called barrister. I've had a long spell as an employed barrister in-house at DLA Piper, and I'm going to talk about contempt of court and committal. This talk's particularly well timed, if I may say, as Jonathan and I have spent the last month working all hours securing the injunctions against the tunnellers who dug themselves under Euston Square Gardens to protest against HS2. That work culminated with the High Court granting prohibitory and mandatory injunctions against 7 named defendants and persons unknown. So Jonathan is about as fresh as can possibly be on injunctive relief. For committals, I'm unashamedly going to make extensive reference to a case of mine, as it is the most recent high-profile committal case, where an HS2 protester, Mr. Kukurian, was committed to prison, and that sentence was suspended for 6 months. The appeal against that committal order has just been heard by the Court of Appeal, and we are currently awaiting judgment. Next slide, please. I haven't actually got the slides up, Jonathan. You missed very little in slides, but let's go on to the second slide. Probably unnecessary, actually, in hindsight. It doesn't look like much, but the reality is that this is a huge topic. And this morning, we can only really aim to remind you of the key principles and point out where the authorities and rules are and suggest an approach you may wish to adopt. And for the talk, we've assumed little knowledge, but we know that some of you have quite a lot of experience. So please do feel free to chip in with comments and questions in the Q&A box, which is open, and I will keep monitoring throughout the talk. Usually these sessions would be in person and a little bit more interactive, so anything we can do to recreate that's very welcome indeed. Jonathan and I are aiming for 10 minutes of Q&As at the end of the talk, but given that we're barristers, there's a very good chance that we're going to overrun our speaking slots, and you all have places to be, no doubt. So on the very last slide, we've included our email addresses. Please do get in touch if you have any burning questions. We'll be very happy to help. Without further ado, then, I will hand you over to Jonathan, who will talk to you about injunctions.
Thanks very much, Michael, and good morning to everyone who's with us. As Michael said, I'm going to cover injunctions in broad overview, and as you can see there, I'm going to go through the basis for injunctions, the types of injunctions you might find, the tests that the court will apply, the procedure, and some final matters to do with and final injunctions. So then the first point to note is that the jurisdiction for injunctions is a very broad and old one. It's the court's equitable jurisdiction, and in the past was a remedy only available in the Court of Chancery. Now, however, it's been quite long confirmed, I think since the 19th century, that this power is available to other courts, in particular the High Court, and we see there Section 37 of the Senior Courts Act. That should be courts, not senior court, which gives the court the power to make an injunction by order in all cases in which it appears to the court just and convenient to do so. So that is a very broad discretion indeed. That's for domestic injunctions. For international injunctions, I just give the reference there to Section 25 of that 1982 Act. International injunctions fall outside the scope of this talk today, given the time constraints. And it's been noted, as I said, the very wide-ranging discretion that the court has in that Fourie and LaRue case. Now, injunctions, that is the court ordering a party to do something or not do something, can be made at either the final stage of proceedings, so once trials happened and judgment has been given, or, and this is of more interest to us today, in the interim stage of proceedings, so before final judgment has been given. And where the injunction is made at an interim stage, the court has to make a judgment call on what the right outcome is, deciding on the course of action that causes the least remediable prejudice to one party or another, and that's explained very well in that National Commercial Bank Jamaica case. And finally, for an injunction, in general, there must be an underlying cause of action that founds the basis for the court stepping in at all. So you have to have some claim that you are bringing, and then the application for an injunction is a sort of supplementary aspect to that claim. However, I'll give the reference there to a provision of the CPR, which says that it is possible for the court to make an interim injunction that doesn't exactly match the final relief that you're seeking at trial. And I'd also mention at this stage that the court can make an injunction of its own motion, and it can be made in response to a defendant. So a claimant could bring an application for an injunction against a defendant. The defendant could bring a cross application, and it might be that the defendant is successful but the claimant is not, or rather the applicant. That's what happened in one of the rounds of the recent HS2 litigation that Michael and I have been involved in, that he referred to at the beginning. The claimant brought an application for an interim injunction, which was refused, and HS2 brought a cross application, which was granted. So there's quite a lot that can go on at high speed. I'm going to then to look at the nature. I suppose I've covered this really. There are two types of injunction broadly. The court can order someone to do X and or not to do Y. So that's how we have those two forms, mandatory and prohibitory. And that can be in response to a wrongdoing that has already occurred or in respect of a feared future wrongdoing. I've given you the Latin phrase quia timet then, which means because he fears. So it can be used preemptively to prevent wrongdoing happening at all. But where it is sought on that preemptive basis, the applicant needs to show a strong possibility of the wrongdoing happening, and that wrongdoing will cause irreparable harm, which can't be adequately compensated by damages and can't be easily reversed. And then that final bullet there, an injunction can be against named defendants, typically, or where the defendants are not known, where their identities are not known, the injunction can be against persons unknown. And in the latter case, applicants need to be very careful as to how they define and specify the class of persons falling into that persons unknown category. So I'm going to then just some typical examples and circumstances where interim injunctions are frequently sought and obtained. I have no doubt that many of you will be familiar with a number of these applications, perhaps the most high profile being the journalism defamation context. I'm not going to cover the sensitive subject of super injunctions here, but I think people will have heard of those. We're going to focus on the first three categories: trespass and protest, gypsies and travellers arriving on land without permission, there are a lot of cases of that kind, and unauthorised waste, fly tipping, and nuisance. But you can see there that the range of applications of this jurisdiction of the court. So, for the test that the court will apply when a party makes an application for an interim injunction is found in the American cyanamide case, which should be familiar to anyone who has done the bar course, at least, if not the solicitors who have done the LPC. This test has essentially three stages, and the first stage there, as you can see, is that there must be a serious question to be tried. So, as you recall, I said there needs to be an underlying cause of action, and that needs to be a serious question to be tried. Now, that's not a high threshold, and the Kane case there that I've given reference to emphasises that it's a low threshold. It is an issue for which there is some supporting material and an outcome which is uncertain. So that's the first stage, which is fairly easily passed. The second and third are more challenging. So the second is whether damages would be an adequate remedy. So whether, in lieu of an injunction, damages paid by the defendant to the claimant after trial or after giving an undertaking would be an adequate compensation for the wrongdoing. And if that's the case, the court will not usually grant the injunction, because it's not just to do so where a money remedy will come along later in the day and put matters right. If, however, damages paid by the defendant would not be an adequate remedy, then the court will consider, if the injunction is granted against the defendant, there will be an adequate remedy in damages available to him under the claimant's undertaking in damages. So it then turns to look at the other side of the equation, as to whether, if there is to be an injunction against a defendant, the risk that in the end it turns out that the cause of action was hopeless, the claimant is able to satisfy for any damages caused as a result of the interim injunction by paying. However, the claimant's inability to compensate in damages in that circumstance is not fatal, and that was emphasised in the Allen and Jambo Holdings case that you see there cited. And the third and most important limb of the American cyanamid test is the balance of convenience. And that's fairly simple. It's as simple as it sounds, which is that the court looks at which course of action carries the lower risk of injustice. And the court will start from the position of preserving the status quo, although clearly in some cases that would mean granting the injunction to prohibit harm happening. Once the serious question to be tried test is satisfied, the court will not generally continue to look at the strength of each party's case in huge detail at the interim stage, although subject to what I say in a moment about where the test is modified. So turning then cases or circumstances where the interim injunctions test from the American cyanamid is modified. The first example where this is the case is where the interim relief that's sought by a party will effectively dispose of the proceedings in their entirety. So an example one might think of this is if you wanted to get an injunction to prevent a particular jockey from riding at the Derby, and the horse race is the next day at 3 p.m. Well, if you've got your injunction and you prohibited this jockey from riding at the Derby, but once that day is over, doesn't matter if there's a trial in 2 months' time because the matter is done and gone. So where the interim relief would effectively dispose of matters, the court applies a higher degree of scrutiny of the merits of the case. And then I've given some other examples where there's a modified test, freezing orders, search orders, and public law proceedings. But I'm going to pause to focus particularly on the last bullet point there, which is human rights. And where the injunction affects the right to freedom of expression, there's a specific provision of the HRA 98 at section 12.3, which, although it's expressed as referring to publication, it's been held that it includes protest. So it can include cases where trespass is being sought to be restrained, and that trespass is a means of protest. And 12.3 states that relief is not to be granted so as to restrain publication before trial unless the court is satisfied that the applicant is likely to establish that publication should not be allowed. So again, essentially, there's a higher threshold to be applied in cases concerning freedom of expression. To interim injunctions against persons unknown, and this is a particularly challenging and I think can be unwieldy area, which Michael and I have come across in our work that he's already referred to. But it's an important jurisdiction of the court, which can be very useful to because essentially there will be cases where the identity of the defendants cannot be known in advance, but there is a real risk of wrongdoing occurring, and the defendants can only be known by their description or falling into a particular class. So this is often used for protester cases and also for online harassment cases as well, I gather. And the Canada Goose case there is the touchstone now, which, as you can see, is pretty recent. There was a glut of Court of Appeal authorities that came along last year and the year before, which set out the approach. And I'm not going to read those seven tests there, but they are very important, and they create some challenges for the applicant where you're seeking a person's unknown injunction. So essentially, that you have to do your best to identify, even though you can't when a proceeding starts, and that identification and the terms of the person's unknown have to be closely tied to the alleged unlawful conduct, and there need to be clear limits to what is sought, so that the injunction doesn't end up being an injunction against all of the world and being too broadly cast. And you can see why the courts are anxious to be careful about how this is applied and to create defined limits, because, as Michael will come on to, breach of an injunction with a penal order on it, with a penal notice on it, can lead to prison ultimately. So the court, although they're being asked to make decisions at pace often with these sorts of cases, they are applying a high degree of scrutiny. And the Enfield case I give there is interesting because it's Mr. Justice Nicklin discussing the difficulties, the conundrum that an interim injunction against persons unknown can create. Essentially binding non-parties at the interim stage, but then when you come to the final injunction stage after trial, it's very difficult, although not impossible, to have an injunction against persons unknown. So there are lots of tricky issues to be dealt with there. I'm going to just touch on a sort of related matter, which is wide-ranging injunctions, which is not just against particular classes of person, but persons falling into a description across a broad area of land. And this is again an area where the courts are becoming increasingly chary of applications that are cast too broadly. And you can see some criticism from, I think it was Lord Justice Coulson, that applicants there's been a feeding frenzy of borough-wide injunctions, but they are useful for applicants to prohibit unlawful encampment or fly tipping, and they've become very popular. So I'm then going to briefly touch, of course, one of the reasons why I should mention that there are many cases, authorities concerning gypsies and travellers, is because there are real Article 8 issues over trying to get injunctions against people whose homes are potentially threatened by an injunction. So the courts are very cautious of that and needs care. Applicants. Then briefly, the procedure for seeking interim injunctions, I give it there. It is, I'm not going to read out everything, but the point is you will have a procedure that's required for your underlying claim, and also there's a specific procedure for the interim injunction application, and those are not exactly the same thing. So there I've given the example of a trespass claim, which has particular requirements. And then you've got the requirements of the interim injunction application itself, governed by parts 23 and 25. And there are also questions about which court you bring your claim in and which court you bring your interim injunction in, which will be important. That I've then referred to service there, and the second last bullet point, I'm going to come on to that in just a moment. Now, to continue on this, there's a general requirement for notice in any application. CPR 25.3 I give there as the reference. However, often these interim injunction applications will be brought without notice, and that can be for very good reason. You can think in a freezing injunction, there is a need to take advantage of the element of surprise. And indeed, in fly tipping or protester injunctions, the need for the injunction is often urgent. So it is possible to depart from the usual rule that notice has to be given, but that have to be good reasons for that. And in any event, informal notice needs to be given if possible. And where you make a without notice application, the applicant needs to give an undertaking to serve and issue the claim form. Usually, I should say, the court will require such an undertaking, and to pay damages to the respondent if it later turns out the injunction should not have been granted. And then a particularly important part of the requirements on an applicant for a without notice application is the requirement for full and frank disclosure. So you need to highlight all the positive and the negative aspects of your case to the court, because as is the nature of without notice, the other side are very unlikely to be there to be able to make their own case. And that's a very serious expectation of the court. And usually with a without notice application, you'll get a return date hearing a few weeks after perhaps the initial hearing for the respondents to come back, having had time to usually take legal advice and get representation. Very briefly then, I'm going to touch on variation, discharge and appeal of injunctions. Often injunctions will contain, or the orders that contain injunctions will have a liberty to apply clause, so a respondent can apply to vary or discharge. And generally, where an application is refused, you simply reapply if you're the applicant, or you can appeal the refusal, but the proper approach it's agreed to be is generally to reapply in most cases. And where you appeal, it's likely you'll need to request expedition, and the appeals have to be on points of principle, not simply the general jurisdiction of the court. So then I think to final injunctions, where the claimant establishes their right at trial, the court will grant a final injunction in certain cases, but they won't do so where this would require constant supervision by the court or where damages will sufficiently compensate the claimant. So you know, it may not be that you can convert your interim injunction into a final injunction in exactly the same form when you succeed at trial. But this may still be possible, and I've given the bullet points there of some examples where it may still be possible to get such an injunction. For example, restraint of trespass and vindication of property rights. And final injunctions against persons unknown, I've noted there are pretty exceptional, but there are a couple of cases. I think both of those that I've cited there are harassment cases, where it was necessary to continue the relief against persons unknown, you know, not perpetually, but after trial, permanently. So that, I hope, is in a whistle-stop way a tour of the interim injunction, or generally the injunction field. I'm going to now hand over to Michael, who's going to look at contempt of court. Thank you, Michael.
Thank you, Jonathan. So what's the contempt of court that we're concerned about this morning? Contempt's a vast topic, so I can only brush over the general principles which apply to most contempt proceedings, particularly in the High Court. Mrs. Justice Norris summed up the jurisdiction pithily in Munir. It's an important point to bear in mind. Although, of course, your claimant clients will be seeking to secure compliance or punish non-compliance with an expensively won injunction order, and your defendant clients will be seeking to avoid sanction for whatever activities they have or have not been carrying out, it's not the underlying cause of action which founds the contempt jurisdiction or which it seeks to punish. It's the failure to comply with an undertaking to or an order of the court. And that goes to the rule of law and to the authority of the court. It's that serious. And that should be the basis of any application you make or any defense you make, the focus on what it is that the contempt jurisdiction actually seeks to deal with. Next slide, please. Contempt of court can be criminal or civil. We're concerned this morning with civil contempt, which, although punitive, has the primary purpose of the court coercing compliance with its orders, ensuring that the injunction order is obeyed. And contempt applications are usually brought by a party to the proceedings, but the court can act of its own volition, as Tommy Robinson found out in his committal case. Nevertheless, the civil contempt jurisdiction is quasi-criminal. Unsurprisingly, given that the liberty of the subject is potentially at stake, the rules regarding committal are stringent and designed to protect the defendant. And the standard of proof on a committal application is to the criminal standard. And that's really important context at the outset. Given that standard, each element of contempt proceedings faces a high hurdle for claimant. It's also worth noting that in contempt proceedings, there's no jury to be dazzled by expositions of the meaning of beyond reasonable doubt. It's the judge who must be sure on the evidence before him. Next slide, please. Thank you. Just setting out there some of the sources of the contempt jurisdiction. I've highlighted it in red, but if you take one thing away from this talk, please take this away. The rules have changed relatively recently. And to prepare this talk, I checked quite a lot of the guidance and articles available online, and all related to the old rules. It was only Westlaw, actually, which I found was current. I'm sure Lexis is as well. It's important, therefore, that you do look at the source material for the CPR just to confirm that you are operating under the right rules. The old CPR 81 was criticised on account of it being overly complex, repetitive in parts and unclear in others. It had come together in a largely piecemeal basis. It was replaced entirely on the 1st of October 2020 by new CPR 81, which streamlines and simplifies the civil jurisdiction into 10 rules of general application, which formalise many of the requirements which have been established in the case authorities and amends some of the language around the jurisdiction. For example, we now have claimants and defendants rather than applicants and respondents. Unlike most attempts to simplify rules, my initial view is that the new rules are likely to be pretty effective, actually, and are a good change. It remains to be seen how they're tested and knocked around a bit, but I think actually it is going to be a successful change, given how broad and how poorly drafted the old CPR 81 was. It is important, though, to make clear that the new, the authorities pre the new CPR 81 remain good law. CPR rules don't trump the common law. Presumably, the only exception to this is going to be where case law concerns the application of old rules, which have since been removed or amended. And in that instance, I'd suggest that the authority is going to be readily distinguished by the court. Next slide, please. I've included this slide to outline the technical approach to contempt proceedings in a civil jurisdiction and how an application is brought. It's important, obviously, that you use the correct forms. It speaks, I hope, for itself, but one point to draw out is that permission is required where the application is in relation to an allegation of knowingly making a false statement in a document which has been verified by a statement of truth or a disclosure statement. You'll also be pleased to know that permission is no longer required to bring committal proceedings for breaches of a solicitor's undertaking. Next slide, please. CPR 81.4 is critical. It will become the bane of claimants and the boon of defendants in time. It sets out the 19 procedural requirements for a contempt application. I've emboldened that on the slide, as that feels to me like a lot of boxes to tick and a lot of potential for error. Some of the requirements, though, relate to the court's approach, and it's important that the claimant reminds the court of its duties under the rules where required. I haven't set them out in the talk, but it is important that if you are considering a contempt application, you look through CPR 81.4 and literally do the tick box exercise as you go through, obviously until you get to the last ones which concern the court. It is difficult to make good any defects in a contempt application given its quasi-criminal nature. So it's important that the written evidence provided with the application is solid by affidavit and deals with the procedural and evidential points in full. Rebuttal or reply evidence in response to the defendant's case is permitted, but as ever, that's not an opportunity to raise fresh matters or to repair procedural defects. The procedural requirements codify the various protections which have been given to defendants in the common law. It's critical in any committal application that the defendant understands what, when, and how they are alleged to be in contempt and has adequate time to secure representation and prepare a defence. That matters perhaps less in respect of commercial and advised clients, but very often the contempt jurisdiction acts against gypsies and travellers and protesters who aren't legally qualified, and there's no real reason to appreciate that they'll understand the rules. So it is upon claimants to ensure that the defendant or potential defendant knows what is being alleged and knows what opportunities he or she has to seek to defend the application. It's also worth noting that CPR 81.4 now confirms that if criminal charges arise out of the same or similar incident, the defendant has a right not to answer questions which might incriminate themselves. This is important if you're implying to commit or seeking to defend protesters, for example, who very often have been arrested for Section 10 offences, obstruction of High Court enforcement officers, or offences such as aggravated trespass. It's worth noting, though, that the fact of a criminal prosecution doesn't oust civil contempt jurisdiction, and it is possible to twin track both and to be in court on the same matter in the civil and criminal jurisdictions. It becomes relevant potentially to penalty and the court's approach to sanction. CPR 81.5 provides that personal service is required for an application, and when dealing with protesters or unknown trespassers, it can be quite difficult to find them to serve the committal papers. A good starting position is for the claimant to fulfill the requirements of any alternative service provision provided for in the underlying injunction order, but also to note that the court has the power to make provision for alternative service where required, so long as the claimant has shown that they've done whatever they can, frankly, to bring the proceedings to the defendant's attention. Next slide, please. This is the critical slide, but I'm going to actually deal with it relatively quickly. It sums up what needs to be proved to the criminal standard in contempt proceedings, and I hope it largely speaks for itself. It's not necessary to show that the defendant intended to disobey an injunction. So in that respect, contempt's strict liability. However, confusingly, the action of breaching the order must be deliberate in the sense that it's intentional, it wasn't a mistake. In other words, a claimant doesn't need to prove deliberate defiance of a court order. It's enough that a person knew of the order, knew the general terms of the order, such as don't build on the land, but they did or didn't do the act anyway. Next slide, please. If the committal application succeeds, the court has some pretty draconian sanctions, and it's often said against civil committal applications that actually the punishment for example, trespass under the criminal jurisdiction is far less than in respect of civil contempt. But as I said right at the start of my section, it's not the underlying trespass that's being punished, it's the defiance of the court's order, and that's why the sanctions are so high relatively and include imprisonment. The maximum sentence is 2 years. Imprisonment is seen as a last resort, and the authorities generally point towards a suspended sentence for a first-time contempt law, although depending on the seriousness of the breach, that does not entirely protect defendants, and there are certainly numerous cases where defendants have been committed directly to prison as a result of their contempt. Very often, sanction will be dealt with separately by the High Court, and the court will consider reports on the defendant in a similar manner to the criminal courts. Similarly, the claimant occupies a quasi-prosecutorial role, so shouldn't really contend for any particular sentence, albeit the judge can helpfully be referred to case authority and sentencing guidelines, which make it quite clear what you think the sentence ought to be. Next slide, please. Given the nature of this jurisdiction, it's one in which civil judges tread exceptionally carefully, and judgments are often lengthy expositions of law and how the court has applied it. This is useful for us in keeping up to date with developments in the jurisdiction. I've listed on this slide key cases which I'd suggest reading in order to gain currency in contempt proceedings, the current state of the law. As I say, we're waiting for the Court of Appeal's judgment in Kikurin, so it might all change in the next couple of weeks. Kikurin at first instance, Mr. Justice Marcus Smith sets out the relevant legal principles referring to case law and how it's all applied over, I think, 62 paragraphs. So I would commend it to you as a good summary of the jurisdiction, albeit it was before new CPR 81. Yaxley Lennon is the Tommy Robinson case I referred to earlier. It's got useful commentary on the strict liability nature of contempt, approach to human rights, freedom of expression type arguments, and actus reus mens rea of contempt. Quadrilla Boland cases are protester committal cases. Again, they deal with general principles, human rights, and particularly sanction of protesters found in breach of civil injunctions. And absolute living deals with procedural requirements under the old CPR 81, which, as I say, will need to be looked at through the prism of the new rules, but again is good case law, which is relied upon by the courts. I've just seen we've got a question, so have a quick look and see if it's to be dealt with now. Yes, thank you, Anna. I'm dealing with that. I'm coming on to that in the very next slide. Thanks, Jonathan. I thought it'd be useful now to provide a few tips from recent court cases, which I've divided up into pro-claimant and pro-defendant comments. Firstly, on the claimant side, be aware that along with the new rules, there are new court forms, so they should be used. Secondly, although video and photographic evidence is not determinative, judges in a number of cases have commented on how useful they found photographic and particularly video evidence. My advice actually is to document everything by video if at all possible. This is equally as important for procedural steps, as well as proving the breach of an injunction order. The best way of proving personal service of an order or committal proceedings is a video of someone handing the papers to the defendant, whether or not the defendant then goes to take them. When you take that video or photographic evidence, given that your committal proceeding could be happening 6 months, a year later, depending on how long it's taken you to build up the case, it is worth getting your affidavit evidence sorted there, so the court has the basis of why that video was taken, when it was taken, who took it, what the day was, because it is a snapshot in time, and the courts are aware of that. At the committal stage, very often, particularly in commercial proceedings, the contempt proceedings are in front of the same judge who made the order. In public and planning law context, this is less often the case, and judges are wary of delving too deeply into another judge's order, but such analysis is not off limits, and indeed I go to that in the defendant's bit. But for that reason, it's essential and critical that the underlying order is sound, has been served correctly, maintained on site, and so on. In Kikurin in the High Court and the Court of Appeal, the defendant made hay with two issues, really. First, he said that the physical demarcation of the injuncted land wasn't clear, and the court couldn't be certain that the red line on the map was the same as the fence line on the ground. At first instance, I tried to suggest to the judge that the geographical boundaries of the injuncted land could be determined to the civil standard rather than the criminal standard, but quite rightly, I went down in flames on that point. Secondly, Mr. Kikurin asserted that although alternative service had been provided for in the underlying order, there was no evidence that HS2 had complied with the requirement to check and replace the orders posted on the land. And on that basis, it was argued that service hadn't been affected. I think the Court of Appeal is going to reject both arguments on the facts, but it shows the importance of a potential claimant complying with all of the procedural requirements for the whole course of dealing, from injunction to committal. Briefly, next slide, please. Again, brief food for thought comments, as defending a committal application deserves its own talk. And I have to say, I think you start off in a difficult position, as usually the court has already exercised its jurisdiction in granting an injunction. The first critical step is to determine whether or not you think your client is actually in contempt and how serious that might be. In my experience, clients often don't consider that they've breached the order, or claim not to have understood the order, or think that there's some excuse which is sufficient. And the analysis of that position can sometimes cause some pretty robust advice in the face of the potential sanctions. And there are two mitigating steps which should be considered. The first, and probably the most important one if you're defending, is doing whatever it is in the order, just comply. As already explained, the jurisdiction exists to compel compliance and to uphold the authority of the court. And compliance, even at a late stage, can go a long way to mitigating a difficult position. And second, don't forget that a contemnor can apologise. Again, that upholds the authority of the court. This can be difficult to achieve with protesters, as very often they consider their actions are justified and are determined in any event to be martyrs for the cause. Whereas by contrast, commercial clients start grasping at any possible option to reduce their possible sanction once they understand the serious consequences of the contempt jurisdiction. Third, my view, the best point to attack in defence is in the procedure. What was the order served correctly? What knowledge did the defendant have? And these are all points raised in the Kikurian committal, which were difficult to deal with. Fourthly, as suggested, a judge is likely to be pretty wary of looking too deeply into an order made by another judge. But that's not to say that the underlying order goes unchallenged. Is it easily understood? Is any language ambiguous? What areas of uncertainty are there that can be exploited to explain why your client has inadvertently breached an order, or it's not clear what exactly it was that he was injuncted from doing? Lastly, although largely unsuccessful so far, I think it's inevitable that human rights arguments around freedom of expression and the right to protest are going to gain some traction, as those arguments are slowly but surely being more and more refined through the case authorities. I think the position still is to take all the Human Rights Act points you can still take in defence. My last slide, please. Now, you might think that this final slide of my section is entirely self-serving, and you would be right. However, it will be counsel who eventually has to explain the position on compliance or otherwise with the various requirements or rules to the court. Injunction and committal work is an area where I would say it's a real benefit to get counsel on board at an early stage, particularly in relation to driving home to clients either how important it is that they comply with the orders of the court, or how important it is that they comply with the procedural requirements in an order and/or contempt proceedings. As I've indicated, the key, in my view, to a successful committal application lies in the preparatory work for the injunction, let alone the contempt proceedings themselves. So that's why emboldened and exclamation mark procedure is key to this. That's all I've got to say. I'm going to hand back to Jonathan in case he has any further comments to make. Thank you very much for listening, and I'll have a quick look at any questions that have come in as well while Jonathan finishes up.
Thank you very much, Michael. Given the time, I don't have a huge amount more to add, but just to thank you all for attending, and I hope that this session has been useful, a useful introduction to this area of the law. Yeah, that's all I think from me, unless there are further questions, Michael.
Thanks, and I hope I dealt the question. The white book obviously hasn't been updated. I haven't looked at the commentary actually recently, but there are new forms, as I understand it. They are enforced now, so I would use your N600 now rather than N244. And I think
agree with that.
That is all for everyone. Yes, of course, that's what you're doing right now. Well, look, thank you everyone for listening, and we'll leave you to get on with your days now.
All the best. Bye-bye.